My name is Lorna McCallum. I'm joined by Dan Jackman, and we're the reporters appointed by the Scottish Ministers to carry out an examination of the application under Section 36 of the Electricity Act for 5 turbines on land south of Ray, Caithness. I think most people taking part today are going to be familiar with the technology that we're using. Could I just ask people to keep their mics on mute, please, if they're not speaking? And anyone who's just observing in the background, if you could also keep your mics on mute at all times, please. If anyone wishes to ask a question or intervene, if you could raise your hand, and I will try and do my best to keep my eyes on the screen. And just a couple of housekeeping points to note before we begin. This meeting is being live streamed and will be available to view on the DPA website. By participating today, you are consenting to the recording, storage and use of this material for webcasting, training and keeping of records that are available for use by the public. I'll be keeping a note of the discussions today, and this will set out all of the procedural arrangements that we agree, so no one needs to take notes. If anyone is participating on a joint basis, if I could just remind everyone about social distancing protocols, please, and ask everyone to make sure that they've got their phones on silent, please, or turned off. Does everyone have a copy of the agenda available? If not, then it is available to view on the DPA website under the case reference. Okay. So the purpose of today's meeting is just to discuss the procedural arrangements as set out in the circulated agenda, and there will be no discussion of the merits of the case today. So as far as I can see, we have most of the parties who've said that they would take part. I think I'm perhaps missing one, which is, I think perhaps Nature Scott might be missing. Okay, they may wish to join later. Could I just ask the parties that are actively participating to introduce themselves, and could I turn firstly to Mr. Trinnick, please?
Thank you, ma'am. Yes, Marcus Trinnick, representing the applicant in today's meeting, and I will be representing them at the inquiry. I'm instructed by Peter Nesbitt of Evershed Sutherland, and I see that Kirsty, yes, she is on the call, good. Kirsty Smith of Evershed is on the call, accompanied also by Nick Sage of Infinergy. Thank you.
Thank you. Mr. Finlay, you're acting on behalf of the council. Could you perhaps introduce your party, please?
Yes, afternoon, ma'am. Yes, James Finlay, Queen's Counsel, appearing on behalf of the council. I will also be appearing at the inquiry. On the call today, I think we have Dr. Wimble, who's going to be giving our landscape and visual impact evidence, Simon Heinsohn, who deals with planning policy, and Karen Lyons, who's the inspecting solicitor. Thank you.
Okay, thank you. And Mr. Kelly, I believe you're acting on behalf of the Ray Area Wind Farm Opposition Group. Could you introduce anyone you have with you today?
Thank you, ma'am. Ian Kelly, planning consultant, acting on behalf of RAWOG. My clients will be listening into the live feed, as I understand it. I have a point to raise with you about Nature Scott. Slightly surprised they're not here. I can either do it under the individual evidence topics or take it at a time to suit yourself, ma'am.
Okay, I think what we'll do is we'll check first of all to see, is there anyone from Nature Scott has joined the meeting? Can't see anyone. Nope. Okay. I think we have RSPB with us today. Could you perhaps introduce yourself?
Hi, yeah, my name's Esme Cleland. I'm a conservation planner with RSPB Scotland, and I'm here with B. Ailing, who's a conservation officer with RSPB Scotland. So we've previously confirmed that we wouldn't be taking part in the inquiry process, but we're just here at the request of yourselves.
Okay, thank you. So I think Mr. Kelly, who we're missing then is Debbie Skinner and Catherine Harry from Nature Scott. I'm not sure whether they've had difficulty in joining us. So do you want to let me know what your point is just now, and we'll see if we want to come back to it later on in the meeting.
Ma'am, it's a very simple point which may come up again once the updated cumulative information becomes available. So far as RAWOG is concerned, as an impoverished local group, and having regard to the emerging wind farm situation along the whole north coast of Caithness and Sutherland, it's the view of the local group that Nature Scott must participate in this inquiry in all evidence sessions, and for them not to do so would, in Rawog's view, be a dereliction of their duty. And I very much hope that the members of the Highland Council present will support Rawog in this very firm view that Nature Scott should not be allowed to absent themselves from these critical proceedings. I'm happy to leave it with you, ma'am. I'm not looking for a ruling today, and it may come up as further information is produced, but Rawog is very clear of the view Nature Scott should be here.
Okay, thank you for that, Mr. Kelly. I'll make a note of that point and we will come back to that later. Okay, thanks very much. If at any point the representatives from Nature Scott join the meeting, we will go back to and ask for introductions at that point in time, but we'll press on at the moment. Okay. Just before we move on to the second item on the agenda, we do have one preliminary matter. We've received an email of the 11th of February from Eversheds regarding Limekiln 1. We propose to address that under agenda item 8, so we will come back to that later. So agenda item 2, parties will be aware that there's no prescribed rules for the conduct of inquiries held under the Electricity Act. Therefore, the DPA has published a code of practice for handling such inquiries, and it sets out the procedures to be followed. It aims to ensure that proceedings will be conducted in a proportionate, fair and transparent and efficient manner. Most of the parties here today will be aware of and will be familiar with the code, but if there is anyone who's not, then it is available to view on the DPA website, and I will enclose a link of it in the notes of my meeting. Okay, if we could turn now to appendices 1 and 2 to the agenda, please. We have set out within these our preliminary thoughts on the means by which we propose to gather the evidence to write a report for ministers and the provisional list of matters to be addressed in this case. So I'll shortly seek parties' views on all of those. I will also deal with the timing of the inquiry under agenda item 5. I think we may have some parties appearing today that are listening in the background that are not familiar with the process. Just for the benefit of those parties, I'd clarify that in the Appendix 1, where we've indicated there will be no further procedure, that doesn't indicate that those matters are not important. It means that we feel that we've got sufficient information in order for us to write a report to the ministers. We're proceeding at present on the basis of a virtual inquiry. I will, however, discuss alternative arrangements when we get to agenda item 5. So we are seeking one inquiry session on landscape and visual impact, 2 hearing sessions in relation to energy and planning policy and conditions, and we have proposed that only one topic, ornithology, be dealt with by further written submissions. Just in the way of explanation, the RSPB position at the moment in writing is that there is insufficient information to reach a conclusion that there would be no adverse effect on the integrity of the Caithness and Sutherland's peatlands SPA in relation to potential impacts on common scoter. Parties are likely to be aware that where a proposed development is likely to give rise to significant effect on the SPA, the Minister, as the decision maker, will need to undertake an appropriate assessment under the habitats regulations. We will need to address that matter in our report, which is why we're seeking further written submissions, or we seek further written submissions. What we feel we need to do is clarify whether we have sufficient information to allow an appropriate assessment to be undertaken and for a conclusion to be reached on the effects on the SPA. If further information is required, we'll need to establish what additional information will be necessary. Therefore, we're proposing to direct written questions in these matters to the RSPB and to allow Nature Scott and the appellants to respond. So before I proceed to seek party views on procedures, I would wish to turn to the RSPB's position statement of the 12th of February and just clarify one point, please. Is RSPB formally objecting or not to the proposed development?
Yes, it is a formal objection. Yeah.
It is a formal objection. Okay, thank you for that. Okay, if we can move on now and seek the views of the parties, I'll seek the parties' views on the procedures, the scope of the topics, and we'll turn firstly to the council, followed by, turn firstly to the applicants, then the council, followed by Mr. Kelly, and then I'll come back to seek the position of RSPB and Nature Scott if they have joined us by then. Okay, so Mr. Trinick, could I ask you whether or not you're content with the procedures we have set out and the topics we've set out in Appendix 1?
Yes, entirely happy. I've got no comments to make on Appendix 1 at all. On Appendix 2, I just query what you want to know about aviation lighting on the basis that there is no requirement for civil or otherwise visible aviation lighting, but only for infrared lighting for MOD purposes.
Okay, thanks. We were just seeking clarification on that point. I think you've given us the answer that we were requiring. Okay, thank you very much. Mr. Finlay.
Our only comment on Appendix 1 is that we'd be content with a hearing session on landscape and visual, and for energy and planning policy, that could potentially be done in written submissions, but that's the position we adopt at most inquiries, and obviously it's going to be a matter for you as to how you wish them to be conducted. As to Appendix 2, just to clarify that Highland Council weren't intending to offer any evidence on wild land, and it may be a matter for you as to the extent to which you wish to have the applicant give evidence on wild land, having, as you say, in consideration for the comments of Nature Scott, we will be offering evidence on the other matters. As to energy and planning policy, if that was timed so it came after any statement of agreed matters, hopefully, given Mr. Bell and Mr. Heinsohn are well used to each other's evidence, the actual evidence in dispute can properly focus on the differences, as you indicated already.
Okay, thank you for that. Okay, Mr. Kelly.
Thank you, Ma'am. In relation to Appendix 1, my preference would be for hearing sessions for landscape, visual, energy and planning policy and conditions. If you decide an inquiry is appropriate, then obviously so be it. In relation to ornithology, I'm very constrained in terms of what I can say, but sufficient to say that the spaceport judicial review outcome might affect the ornithology position, and the substantive hearing on that judicial review is the 8th to the 10th of June. In terms of Appendix 2, it's the position of RAWOG that the aspect of cumulative impact certainly arises in relation to wild land, given the very considerable number of proposals on either side of this wild land area, and RAWOG expects Nature Scott to properly and fully address the cumulative impact on wild land. Thank you.
Thank you. Could I turn to RSPB now, and could you advise whether or not you're content with the procedures that we've outlined in terms of your own interests?
Hi, yeah, certainly, as I said before, our decision, our position from the RSPB Scotland was that we wouldn't be taking part in the inquiry, but certainly if there's any further measures, then yeah, we would see that written submissions would be appropriate for that.
Okay. And could I come back to Mr. Trinick? Do you have any comments on the proposition that landscape and visual be held as a hearing session rather than an inquiry?
Yes, thank you, ma'am. No, we would strongly prefer to have an inquiry session for the topic. I think it's justified. We're strongly of that view. Just a couple of other what's just been said. But there's a lot of background noise from some of the...
There is, yeah, sorry.
Does
anyone not have their mic on mute?
Ah, that's better.
Okay,
I didn't quite hear what Mr. Kelly said because of the background noise about something happening on the 8th of June. I'm not sure of the relevance to this PEM. And my third point is yeah, I accept the need for cumulative evidence on wildland areas. I think there has to be a session on that. However, I would leave a question with Mr. Kelly. What we don't want to happen is that SNH decide not to turn up and give evidence, and then otherwise compelled, if they can be compelled to give evidence, and then RAWOG doesn't produce any real evidence either. In other words, we're just pushing an open door. That would be a waste of a session. So I'd like to hear from Mr. Kelly whether his clients do actually intend to produce evidence on wildland rather than ride on the coattails of Nature Scott if they appear.
Okay, Mr. Kelly, could I turn to you, please?
The position is simple. RAWOG has no money to commission anyone. Absolutely no money to commission anyone, and it's not their job to do Nature Scott's job for them. We will rely on Nature Scott. In relation to the 8th and 10th of June, Mr. Trent may be aware, Wildland Limited have permission to proceed with a judicial review of the Sutherland Spaceport, intention to grant permission by the Highland Council. The outcome, one way or other, will have implications for ornithology evidence. And I think that's all I'm allowed to say in terms of the court rules.
Okay, could I just clarify then, if RAWOG have no money, does that mean that there would be no witnesses at all presented by the objectors group?
There will be me, and I am doing the work for nothing for them.
Okay, and which sessions were you saying that there would be no input? Would it just be the wildland session, or are you proposing to participate in the hearing session in landscape and visual, energy and planning policy and conditions?
I will confirm the position in response to the minute of the PIM. At the moment, the intention is that I would appear at all of these sessions if you go ahead with them. The extent to which evidence will be presented will depend on Nature Scotland. It may be that I just sit in and listen to the evidence and ask for a couple of questions. The substantive involvement would be in the hearing session on policy.
Okay, thanks for that. Mr. Chinnick, do you have any further comments?
Well, no, we'll wait and see. I just don't want the whole inquiry session on wildland effects to be set up, only if anyone wants to turn up, except for the applicant. That would be somewhat a waste of resources. In that event, we could deal with the wildland matters by written reps rather than hearing or inquiry session.
Okay, could I just quickly come back to Mr. Finlay? You had said that the council were content for a hearing on landscape and visual impacts. Would you be content with wildland to be addressed via written submissions? Mr. Finlay? Sorry, I can't hear you, Mr.
Sorry,
Finlay.
I didn't quite catch that.
Sorry, I was just saying that the applicants are content to deal with wildland via written submissions. The council had suggested that they would be happy with a hearing on landscape and visual impact. Would the council be content to deal with the wildland issue as further written submissions? Or do the council propose to offer no comment on wildland? Mr. Finlay, can you hear me?
Yes, we would.
For
Quite
the
content for
submissions.
wildland.
Sorry,
We're not going to be offering any evidence on wildland.
Right,
as
nothing
currently.
at all. But
I can hear you.
Right, okay, thank you. Okay, we will take all of that into consideration and we will come back in our note of the meeting. Okay. Could we move on then to item 4, which is agreed matters? So as parties have already noted, we're seeking to focus the examination on the areas where parties do not agree. So as normal practice, we'd be seeking parties' cooperation to produce a statement of agreed matters on the topics to be addressed at the inquiry and hearing sessions, and also request that parties prepare an agreed list of conditions relevant policy documents, relevant development plan policies, and a list of core documents. The Council's already prepared a list of proposed conditions in its consultation response to the Energy Consents Unit. It would be helpful if a combined final response and conditions could be submitted prior to the hearing statements being produced. And for any parties unfamiliar with this process, I would just note that the Scottish ministers do require us, irrespective of our outcome on the proposal, to prepare a set of conditions, and they're prepared, and any discussions take place without prejudice. The focus of the hearing on conditions would be on any conditions where there's not agreement. Where there's any disagreement, we'd expect parties to provide an explanation for their position. In terms of core documents, we would seek that parties work together to avoid duplication. There are already numerous documents held within the DPA core document library, and duplicate copies need not be provided. If those documents are being referred to, then a simple hyperlink to the list of core documents is sufficient. Any further documents can be added to the DPA core docs library, and I'll provide further details in the note of the meeting. Could I ask Mr. Trinick, would you be happy for the applicants to take the lead on preparing and submitting the agreed matter statements and list of core documents initially?
Yes, of course, ma'am. It's not a problem. I think we attach quite a lot of importance to this statement of agreed matters as a way of not only minimising debate in the oral sessions, but also minimising the length of the hearing statements and inquiry reports and preconditions. To that event, I just put down a marker. When we get to timescales, I'll be wanting to see that the statement of agreed matters completed well before evidence is written, so at an early stage. Conditions can follow, but I think the statement of agreed matters, there is an urgency to get on with it.
No, I would agree. I think that would be helpful. Does any other party have any comments? Okay, thank you. So moving on to agenda item 5, we'd initially hoped we do our best to try and determine applications within the timeframes, but it's not always possible. So we had hoped to have the examination in early May. Parties hadn't been able to accommodate that. We did suggest a date of 28th of June, and unfortunately that slot very quickly became unavailable. So I think parties have now all agreed that commencement date would be Monday the 14th of June and not the 21st as noted in the agenda. And we do appreciate that that's a busy time of the year for inquiries, and we're really grateful to the parties for cooperation in agreeing that date. While we're working towards a virtual inquiry at this stage, we do think that we should make some preparations for an in-person inquiry should that proceed, because venues are difficult to secure at short notice. So what we would do at this stage is just ask parties to have some thought about potential venues. You may be aware that we've only had one in-person inquiry so far since this COVID outbreak commenced, and that was in Aviemore. I think some of the parties here took part in that inquiry. If we are to have an in-person inquiry, then any venue that's put to us would need to meet similar COVID safety requirements. So I'll leave that with the parties. If we obviously don't know the local area, but if anyone considers that there may be suitable venues, if they could make the case officer aware at an early date, that would be helpful. So obviously we are not in a position at the moment. Oh, I see someone else has joined us. Sorry, before I move on, do we have either Debbie Skinner or Catherine Harry with us now?
Hi, yes, it's Debbie Skinner here from Nature Scot.
Hi Debbie, thanks for joining us. I will come back to you. So we're now on agenda item 5, but I will come back and go over some of the points. So I'll just very quickly finish where we were on timeframes. We will draw up a nominal timeframe for the inquiry further on in the process, but what we would just wish to seek at this point in time is parties' position of whether or not they think, if we are having a virtual inquiry on the topics that we have discussed, whether they be inquiry or hearing sessions, whichever oral sessions is a week sufficient. Could I turn firstly to Mr. Trinick?
Well, I think we stick with the Appendix 1 suggestions. As for process, I've certainly been through two virtual inquiries in the latter part of last year, and they worked very well using virtual technology for inquiry sessions. I was a little bit nervous before the event, but actually it went very well indeed, so I think it can be made to work. In terms of a physical inquiry, I certainly record our strong preference for that if it's possible, but I'd also ask that, I'm delighted to hear you talking about venues now, because what we don't want is to have to postpone the start date of the inquiry, so it'd be useful to get hold of a venue in advance just in case we can do that.
That would be good. Okay, thank you. Mr. Finlay, does a week seem sufficient to yourself for any oral sessions?
Yes, in terms of timing, I would anticipate the landscape and visual should take no more than 2 days, and may well be less, and a day for other aspects should be sufficient. I echo Mr. Trinick's strong preference for an in-person inquiry if that becomes possible, and making inquiries at this stage of venues should that be possible. And like Mr. Trinick, I've taken part in both virtual hearing sessions and virtual inquiry sessions. Our preference, as I indicated earlier, is for a hearing session on landscape and visual, but I accept that an inquiry session can work virtually.
Okay. Mr. Kelly, do you have any comments on the timing?
Thank you, ma'am. I think a week would be fine. I also would prefer an in-person inquiry if at all possible. If it has to be a virtual inquiry, then one lesson I would re-emphasise from the recent experience with Aracleoch Extension is to stick with the shorter days. We had 3 days allocated for landscape and visual in Aracleoch Extension, and on the middle day we had only a short break in the morning, a short break at lunchtime, a short break in the afternoon, and ran on till about 10 to 5 at night, and everybody was absolutely shattered by the end of the day. So if it is a virtual inquiry, I would strongly urge that you stick to the short days, but that should still be possible within the week.
Right, thank you. No, we do appreciate that. It is very tiring, and we would be proposing to build in additional breaks than you would normally have in an in-person inquiry should we have to proceed down the virtual route. Okay, so before I move further on to talk about the timeframes that we've got in mind for submission of documents, could I just very quickly pop back to item 3, please, for the benefit of Nature Scott who have joined us. Appendix 1 sets out our proposed means by which we will gather evidence for this inquiry, and we had indicated that we would be seeking further written submissions on the topic of ornithology. The reason being that at the moment RSPB have indicated that they consider there isn't sufficient information for a conclusion to be reached on the impacts, or that there would be no adverse effects on the integrity of the Caithness and Sutherland's SPA due to impacts on common scoter. So parties are in agreement that that could be dealt with by further written submissions. The reason that we would be seeking further written submissions is that the Minister as decision maker would need to undertake an appropriate assessment and would need to have sufficient information to do that. So we, in our report, would have to clarify whether or not we consider there is sufficient information for an appropriate assessment to be undertaken and for a conclusion to be reached on the effects on the SPA. So what we need to do is clarify whether further information is required and what further information we will need. So we are proposing to direct for specific questions around those points to RSPB and to allow Nature Scott and the applicants to come back to us with any further comments. Would you be content for us to deal with that topic by that means?
Yes, I think that sounds perfectly fine. Yeah, we're happy to do that. Yeah.
Okay, and does any other party have any further comments to make on that? Okay, right, we have given some thought to timing, because obviously with a virtual inquiry, things have to be done slightly differently, and I know that there's a lot of pressure on people's time round about the same time as our inquiry. There's inquiries either side of it. So given some thought to when we would be looking for the various submissions, inquiry statements would normally be a no-word limit and submitted within 8 weeks, which would be a due date of the 19th of April. Recognitions, maximum of 2,000 words, normally 2 weeks in advance. They would be due on the 31st of May, but that coincides with the bank holiday weekend, so we're proposing to bring that forward by a week to Monday, the 24th of May. Hearing statements, again, no word limit. They would normally be submitted within 4 weeks and due on the 17th of May. I'm booked to be on leave, so I'm asking again, are we proposing again that those be brought forward by a week to Monday the 10th of May. Further written submissions, we will confirm in the note of our meeting when we would anticipate those should be submitted, but we would like to get those off the ground sooner rather than later. Core documents, we'd be looking for a list to be lodged with it by Monday the 3rd of May. And as with hearing statements, all core documents we'd be hoping to have by Monday the 10th to allow adequate time for checking. There's currently, under the COVID regulations, no requirement for a public deposit copy, but if we could be prepared just in case the inquiry goes ahead in person and the position changes, that may alter. So we're very aware of the time constraints in all parties, but we would stress the need for punctuality in the submission of documents. But we're hoping that the gap between the pre-inquiry meeting and the oral sessions should allow parties sufficient time to prepare everything. I'll go into detail a little bit more, and sorry, Mr. Finlay.
Yeah, just a query about the date for producing the main landscape and visual evidence. Dr. Wimble is familiar with the site in a general sense, having given evidence at the first Limekiln's inquiry, but before producing his evidence, he would wish to revisit, which is obviously not an option at present. I wondered whether it was possible to push the date for that evidence back to the end of April, just to increase the window whereby he could visit without having to change the timetable. Hopefully such visits might, by the end of April, be allowed and give him sufficient time to produce his evidence. But I just lay that marker down, okay, as to a concern there, but hopefully, and to ask you for a little bit more leeway in time. And certainly from that would still give quite a significant time before recognitions were due on the 24th of May.
Okay, thanks for that. We're very conscious that the whole COVID situation is fluid, so what we are proposing to do is have a follow-up pre-inquiry meeting where we can firm up these time frames a little bit. Sorry, Mr. Trinick, do you have a point?
It's only to see clarification there, because I'm getting a bit muddled there. I thought that it was inquiry statements, i.e. basic statements of case, which were to be in April, but that the documents, which now include inquiry reports, were to be by the 10th of May. So in fact, Mr. Wimble's full evidence for the landscape and visual session wouldn't in any event on your timetable be until the 10th of May, which may allay his concerns.
That's right, that's right. Inquiry statements, we've provisionally indicated the 19th of April, and recognitions the 24th of May, so that still gives a little bit of time. Does that help, Mr. Finlay?
Yeah, I'd missed that, and I'm grateful to Mr. Trinick. Dr. Wimble's main evidence will be in a document which will be submitted on or about the 10th of May. Yep. And he is sufficiently appraised of the position to be able to, we'll be able to put our inquiry statement in on the 19th of April, whether or not he's had a further site visit by that stage.
Okay, thank you for that. Okay. We will firm up the time frame in due course, but we will indicate in the note of the meeting what our intentions would be with all of those dates. We will also give some further information in relation to the procedures for submitting the documents. At the moment, all the case officers are working from home, so electronic documents can still get to the case officer with no issue, but any hard copies that are required of plans and photographs would need to come to our office. So closing submissions as normal, we'll consider the date for those at the end of the oral sessions. Does anyone have any comments before we move on to discuss site inspections? Mr. Trinick.
Yes, thank you. The statement of agreed matters, a date for that. I'm not sure we've got that down, but I'd be asking that we try and get that done reasonably early in April, because it really helps to have that done to inform the writing of the evidence. Otherwise, it becomes not a very useful document. So I would be looking to 6th or 13th of April for a statement of agreed matters between the main parties, that is Highland Council and the applicant. If RAWOG want to come in and join, I'm not so worried about the timescale, but between the main parties, I think early in April would give the maximum advantage to the document.
I think it would be in everyone's interest to have them well in advance of the inquiry statements. Does anyone have any further thoughts on that?
Well, just that chimes with the point I made when we were going through the schedules, that an early statement of agreed matters, particularly on policy, should significantly reduce the evidence that both parties have to give on that.
Okay, so that was did you suggest the 6th to the 8th, Mr. Trinick?
6th of April is my opening shot on that.
And does anyone have any comments on that? Okay, thank you. Okay, noting on what Mr. Finlay had said, we ourselves will have difficulty in accessing the site at this current moment in time. We are not able to visit the site. So what we're proposing to do is to review the site visit arrangements in more detail closer to the timing of the oral sessions. So I'll come on to discuss that in the next item of our agenda. But again, just to have parties being prepared so that we perhaps can go on site sooner rather than later, if thought could be given to the particular locations that people would like us to have a look at, and to advise us if there's any access constraints at any of those locations. Could again I ask Mr. Trinick if I could leave that in the hands of the applicants to liaise with other parties and provide us with details?
Yes, of course, no, it's not a problem. I think so far as all visits except wildland are concerned, just put down a marker. We won't be asking for you to be accompanied anyway. I see no point in that. There are core paths within the area of the site that you can use anyway, and all the other viewpoints are obviously public. So far as wildland is concerned, we've discussed that. We think you probably do need ArgoCat access to the interior, and we can provide that. ArgoCat will provide the kit to do that.
Okay, that's much appreciated. Mr. Finlay, do you have anything to add on the site inspections? No. Mr. Kelly?
Not at this stage, no, thank you.
Mr. Kelly?
Nothing, ma'am. Content with what's been said.
Okay, does any other party have anything to note on that point? Okay. So, in view of the current circumstance, we're proposing to have a further follow-up pre-inquiry meeting. There is a provisional slot available for us on Thursday, the 22nd of April. I'm just putting that to parties just now, and I'll ask the case officer to confirm with everyone if that is suitable. Hopefully she'll be in contact early next week, but if anyone has any issues with that just now, could you perhaps let me know?
Is that Thursday, the 22nd of April? I may be in a land court hearing, but I think it's unlikely to occur, but I'll keep you informed.
Okay, well, what I'll do is I'll arrange that provisionally, and I'll ask the case officer to contact parties, and if that date doesn't suit, then we can work out another roundabout that point in time. So the DPA point of contact is Laura Walker, and I'll include her contact details within the note of the meeting. So as I said, she's working from home. She can still obtain electronic copies, but hard copies would go to her new address here at Hadrian House. And in view of the potential for a virtual inquiry, we will review the daily programme nearer the time, but normally an in-person inquiry would start at 10 AM on the first day, subsequent days at 9:30, with finishing around 4:30 to 5, with the usual breaks in the morning and at lunch. But we will appreciate that a virtual inquiry is more difficult to organise, so we will give some thought to how we can work that into the timetable if that should be the case. It is intended that the inquiry and the hearing sessions, if they've got to take place by virtual means, would be live streamed and would be available to view on the DPA website. So we've considered that that would give the local members of the public sufficient ability to access proceedings. I don't imagine anyone has any, sorry, did anyone raise a hand there? No? No, okay. So what we will endeavour to do is issue a note of the meeting within the next 7 days that sets out the timeframes that we're talking about and gives our comments on the procedures that we consider may apply. But I just want, before we move on any further, to cover the point that was raised in my preliminary matters, which is there's an email we've received from Eversheds on the 12th of February, which discusses the potential for alterations to the Limekiln 1 turbines. And I wondered if Mr. Trinick, would you be happy at this point to just perhaps go and tell a bit of an explanation for us on both what is proposed and also whether this is relevant background information to this current examination?
Yes, thank you, ma'am. Certainly. There are two reasons for the need for additional information. One is to update the cumulative baseline anyway, because of certain events at Strathy Wood, Strathy South, and a site called Akron. There may be something else I don't know, but those are the three that I know of. There is a second reason in this case, which is that there is going to be, I don't think it's yet scoped, but it's in the knowledge of the applicant because it's the same applicant, there's going to be a proposal to increase the tip height of the consented Limekiln project. Limekiln 2, we call it, I think you call it Limekiln 1, it doesn't matter, the one that's consented. That means that there will need to be some reassessment of the Limekiln extension project on the baseline of Limekiln 2 because of the increased tip height. It's not a major job. The implications for the Limekiln extension inquiry are, as far as we're concerned, solely landscape and visual. There's nothing else to take into account, although all aspects will be looked at in the AI to make sure they are covered. But the main implication for this inquiry is the landscape and visual effects. Now, the document AI will be ready for publication, guaranteed, in the second week of March. That's been nailed down. However, material will become available before that date and will be circulated as soon as available to all parties, rather than waiting for the publication date. Because as a printing process, you would appreciate the delays that date. That's where we are. I don't believe, although others must make their views known, that it impacts on the timescales you've already discussed, but I leave that with others.
Okay. I turn firstly to Mr. Finlay. Do you have any comments to make on that?
I think I'll restrict myself to timescale. No, I don't believe it will do. Clearly, it's only an early stage proposal, and the main judgments will be made against the currently permitted Limekiln. So, in our view, whilst quite right for Mr. Trinick to raise it, there is it shouldn't substantially add to inquiry time or hearing time.
Thank you for that. Mr. Kelly.
Thank you, ma'am. Very simple. I think it will be very helpful. No concerns.
Okay, thanks very much. Does anyone else have any points they wish to raise on that matter? Okay. Okay. Does anyone have anything else to raise? Any final points? I think we're, sorry, Mr. Kelly.
Yes, ma'am. When the last Limekiln inquiries were held, obviously on an in-person basis, there was an informal evening session in which local people could come along and express their views without being cross-examined, but express their views based on short written submissions made in advance. I've been giving some thought to this, and I think there may be some interest in such an evening session, but it only works if you have a face-to-face inquiry. I think it would be very difficult to organise it virtually. And I'm wondering if it might be possible that we just leave it as a possibility just now, ma'am, and then revisit it if it is possible to have a face-to-face inquiry. Otherwise, we may just have to rest with matters as submitted to date. If you're happy and other parties are happy to leave it for the moment, then I'm happy to leave it for the moment, and we can revisit it in April when you have the second pre-inquiry meeting. And just, if you can indulge me on this one, I would be grateful if you could refer to these proceedings as an inquiry. They're not an examination. It is an inquiry. I thought I had cleared this with the chief reporter in a conversation, but it is an inquiry. Thank you, ma'am.
Okay, thank you for that. Points noted. My understanding is that with the initial Limekiln inquiry, that there was a set of evening sessions, like you said, running the basis that there was some prior disclosure of what was to be presented, and that they didn't raise any new matters that hadn't already been raised in the points of objection. So on that basis, I think I'd be happy to leave that for now, and we could perhaps come back to it later, unless anyone has any strong opposition to that.
No, no, I think it was very, I attended that last session, it was very worthwhile, so happy to say that. Someone's not on mute again, I think, I don't know. I did have one other point, that's why I was jumping in there, not just to say that, and that is, earlier in this meeting, there was a discussion between you and Mr. Finlay about whether or not Nature Scott would actually take part in the wildland evidence. I think we ought to bottom that out if possible.
Yeah. Okay, thanks for raising that. Sorry, Nature Scott, you missed out on that conversation earlier. If we could perhaps go back to the agenda, just scroll through. If you have the agenda in front of you, we had been considering that there would be an inquiry session on landscape and visual impacts, which the applicants are strongly pushing for, and the council would be content to either participate in that or have a hearing. The matter of wildland is not something that the council, correct me if I'm wrong, Mr. Finlay, the council do not wish to raise any further evidence on that matter. Would Nature Scott be proposing to participate in any further way in relation to landscape and visual impact or wildland?
Hi there. We weren't intending to participate. I think our landscape advisor is here at the moment. I'm not sure if she's managed to join Catherine Harry. But yeah, we certainly weren't intending to participate in the actual inquiry itself.
Okay. Does Ms. Harry have anything she would like to add? I can see her name, but I can't see her face.
Oh, hello, can you hear me? Hi, sorry.
Yeah, hi, thanks for joining us. It's just, obviously we'd set out how we propose to deal with matters in Appendix 1, and are you content to rest on the submissions you've made in terms of landscape and visual impact and wildland?
Yeah, that's right. Assuming there's no changes to the proposal, we're not intending to provide any evidence here.
Okay. Mr. Kelly?
As I said at the start, and Rawalk very much hopes that we will have the support of the 3 local councillors on this matter. That is unacceptable. It's completely unacceptable that Nature Scott abdicates its responsibility to the natural heritage, protect Scotland's natural heritage interests. If necessary, we'll take it up directly with ministers, as we've done before. They really need to be participating here, given the overall situation. As I say, I don't expect a ruling from you today. It's a difficult position to put you in, but Rawog will be talking to the 3 local members and taking it up possibly at chief executive level with Nature Scott. It's not acceptable. Thank you.
Okay. And just so that I'm 100% clear on Rawog's position on that, you were proposing to participate if we have an inquiry session on landscape and visual impacts, and you would be proposing to address the wildland matter?
Considering it's only myself and we have no resources, we would do so, but it would be in brief. Would be very much in brief. And I am very mindful and respectful of Mr. Trinick's position that it would be almost a waste of time to hold an inquiry session or a hearing session if Nature Scott continued with their current approach. In those circumstances, written submissions would be, I feel, adequate for Rawog's interest.
And we don't currently have an objection from Nature Scott, that's correct? Okay, Mr. Trinick, do you want to make any further comments on that point?
No, I think Mr. Kelly's been very fair. I don't mean in his objection to Nature Scott's position, but in his recognition that if there is no Nature Scott representation at any oral proceedings for wildland, and there won't be any from Highland Council, then there wouldn't appear to be much point in having a full oral session, in which case we can deal with that matter, wildland, by written representations, supplemented by an Argo Cat site visit.
Okay. And if circumstances permit, would you be proposing that would be an accompanied visit to wildland?
Well, it doesn't absolutely need to be, but you need to be driven by somebody on an Argo Cat, and that would be probably the landowner, which means that you probably ought to be accompanied, in which case there need to be 2 Argo Cats, etc., and so it goes.
Okay, right, thanks for that. Those points are all noted. Thank you very much. Okay. Just going back to my agenda. We will obviously in the note of the meeting when we draft that up take into account everything that we've heard today. Is there any other final points anyone wishes to make? Okay. So we would obviously encourage the parties to continue to discuss the case. We want to spend the examination time or the inquiry time on matters where there are genuine differences between the parties. And if no one else has anything further to add, I would bring today's meeting to a close, thanking everyone for their time today, and hope we can agree a further pre-inquiry meeting towards the end of April. Okay, thanks everyone, much appreciated.
Thank you.